Next, from Springfield, we attend a House Judicial Committee hearing on a bill that would change sentencing guidelines for gun offenses. Speakers include Eddie Johnson, the superintendent for the Chicago Police Department. This runs about 35 minutes.
Superintendent Johnson.
Good morning, Mr. Chairman, and to the members of the committee. My name is Eddie Johnson, and I'm the superintendent of the Chicago Police Department. I want to thank you for the opportunity to appear before you all today. In 2016, 768 people were killed in Chicago. That's 768 individual tragedies that have left countless families in grief. Of last year's victims, 92% were male, 78% were African American, 75% were between the ages of 15 to 34, and 91% of the victims were killed with a gun. Those numbers represent multiple generations of young black men who never had a chance to make something of their lives because of illegal guns and the criminals willing to pull the trigger. I've been a police officer for 29 years, and I've seen too many lives cut short and too many parents lose a child. And quite frankly, as an African American leader, I'm disgusted. And as a cop, I'm angry. Because the simple fact is we can do better. Those we all serve in the city of Chicago deserve better. I'm not here to ask the legislature to solve this problem for Chicago. We as a city take full responsibility for doing the things that are within our power to address the problem of gun violence. Right now, when we arrest a gun offender, they may serve a few months in custody. If we arrest and convict them a second time, they might serve a year, if they serve any time at all. These offenders are cycled through a criminal justice system with a severe lack of accountability for the crimes that they commit. They're released back to the streets so quickly that they see no reason to change their behavior, and the cycle of violence just continues in our city. I'm here to ask you for your support for Senate Bill 1722, which is both a pivotal and incremental step in holding repeat gun offenders accountable for making our streets safer. I would also like to applaud the work of the sponsors and the committee on this matter. Before I could continue, let me be clear. I'm not seeking to mass incarcerate minorities or establish additional mandatory minimums or take guns out of the hands of people who hold them legally. This legislation gives judges the guidelines to sentence repeat gun offenders at the higher end of the already existing sentencing range. It also contains predicating violent offenses that will classify an individual as a repeat gun offender, and that's to ensure that we're not casting a wide net, but instead we're using a spear to pinpoint the individuals that are driving the violence in the streets of Chicago. Finally, judges retain their discretion to sentence at the lower end of the current range if they articulate their reasons for doing so in a publicly available statement explaining their decision. This bill does not change the existing sentencing range for repeat gun offenders. Gun offenders sentenced under the proposed language in the bill remain fully eligible for sentence credit, including rehabilitative services. However, if an individual shows a repeated willingness to pick up a gun and use it illegally, those individuals need to pay a price with a sentence at the higher end of the existing sentencing range. That's what I support, and that's what a portion of this bill seeks to accomplish. This bill would hold individuals like James Rogers accountable for his devastating actions. Rogers' first conviction was for battery in 2009. He was convicted again in February of 2010 for aggravated unlawful use of a weapon, aggravated UUW. Under the language of this bill, this offense would be considered a predicate offense. Rogers was sentenced to 2 years of probation for this act. His next conviction for aggravated UUW was in June of 2015. The language in this bill would have required that Rogers be sentenced to the higher end of the existing sentencing range, assuming that a judge chose not to deviate from the guidelines of the bill. Instead, he was sentenced to 2 years in the Illinois Department of Corrections. And sadly to say, Rogers was arrested a third time for first-degree murder on July 13th of 2016 for killing a 39-year-old male. If this bill was in place in 2015, Rogers would have been forced to serve more time, and this act of violence may have been avoided. I believe that we need to continue to identify legislative solutions that will ensure we are targeting the main drivers of violence in Chicago and throughout the state of Illinois. And while I understand the necessity for negotiation and compromise as part of the legislative process, there are amendments to this bill that, quite frankly, make me uneasy. Specifically, the potential for reduced time served for individuals who possess or distribute 100 grams or more cocaine, heroin, or fentanyl, among other criminal justice reforms, even though I understand that these changes were recommended by the Illinois State Commission on Criminal Justice and Sentencing Reform. To be clear, the drug trade is what drives the gang violence in Chicago, and lessening the consequences for high-level narcotics dealing and possession still makes me very uncomfortable. There are other reforms in this bill supportive of the diversion and rehabilitation for first-time weapons offenders charged with Class 4 or lower unlawful use of a weapon or aggravated unlawful use of a weapon, as well as low-level drug property crimes offenses. I firmly support diversion and rehabilitation, but only for less serious nonviolent offenders. In fact, we currently have a diversion pilot in Chicago that connects nonviolent drug addicts to treatment services on the west side of the city, and that's showing significant signs of success, and we're proud of that at CPD. However, I have to say I'm opposed with the language that allows a person who is carrying a gun in public and does not have a valid FOID card to be part of this diversion program. This circumstance is not eligible for probation as part of a change in the law stemming from the murder of an on-duty Chicago police officer, Alejandro Valadez, in 2009. I have to trust that the state's attorney's office will use their discretion to screen and identify eligible candidates who are not individuals driving the unacceptable violence in our communities. As leaders in our communities and our state, we have an obligation to do whatever it is in our power to protect the welfare of the public. And on an even more basic level, as humans, we should be able to look at those we serve in the eye and say with sincerity that we're doing everything we can to help solve this problem. And that's why I encourage you to pass a bill that holds repeat gun offenders accountable. So on behalf of myself, the City of Chicago, and in the name of every person who's been touched by gun violence, I would like to ask you for your support in this legislation, and thank you for allowing me to testify, and I look forward to any questions that you all may have.
I just want to just indicate on the record that the drug offenses that the superintendent referred to that would be reduced, that are the recommendations from the task force, have been removed. Those are not part of this legislation, but also the diversion program would require the agreement of the state's attorney's office and assistant state's attorney to, in situations that you just mentioned with that individual who had the gun without a FOID card, the state's attorney still has to sign off on the diversion program. So there is discretion, and I know this is something that the state's attorney's office will take into consideration if they do believe that someone qualifies and is deserving of that first-time diversion program. So thank you, Superintendent. I'd like to now allow the Senate sponsor, who I've worked with a lot over the last few weeks, to bring this to, again, to closure. That's Senator Kwame Raoul. Thank you.
Thank you, Leader, and thank you, Chairman Sims and the committee for allowing me into your chamber.
It's a temporary assignment.
Let me first say that there was work on this bill that took place over the course of really the last year. The superintendent came to see me last year and voiced support for previous legislation that sought to lend a tool to law enforcement to deal with the gun violence that we're dealing with, not just in Chicago. It's beyond just Chicago, and it was legislation that I opposed because I thought that it cast the net too wide and it employed truth in sentencing, which I think is a policy that discourages good behavior while incarcerated and participation in rehabilitative programming. As a result, Representative Zaleski, Representative Sims, and I took part in a long, difficult negotiation process where we heard from community groups, and we engaged the judiciary, who was concerned about having their discretion removed. And that's how we came upon a departure mechanism that is being used in this bill. This bill has been characterized as a bill that establishes mandatory minimums. That's a falsehood. That's an untruth. This bill does not create a mandatory minimum. If you want to confront that issue, you have to go back in time, because this body, with wide support, supported legislation that created the 3 to 14 mandatory minimum range. What this bill does, which is in the province of the legislature, is lends guidelines to the judiciary as to who within the already existing range should be shifted to the top of that range. And when you think about sentencing, you want to treat a first-time offender different from somebody who repeatedly violates the law. And I think it's particularly important when we're talking about, people have made references in talking about this bill to the 1994 crime bill and the mandatory minimums on drug possession penalty. I think there's a clear distinction between repeat drug offenders and repeat offenders of carrying a deadly weapon on the public way. I lent myself to this negotiation and to this process because of the violence that was happening outside of my home. And it offends me when people have characterized my work on this bill as something that is counter to criminal justice reform, given the commitment I've had to criminal justice reform throughout my career in the legislature. It only requires reading the details of this bill to realize that we've preserved judicial discretion. We have criminal justice reform recommendations that Representative Cabello, Representative Sims, and I, who served on the Criminal Justice Reform Commission, approved. Now, some of them that were originally on there are not on here, and I hope as we continue our work in the legislature, we don't all retire today, that we will continue to work on criminal justice reform. We won't be able to accomplish it all on one bill. I appreciate all the passion that has been expressed with regards to this bill. We do need resources in the community. This bill is not a cure-all. This bill is not a cure-all to the violence in Chicago or outside of Chicago. But I do believe it's something that will help. I do believe that people who've been previously convicted of murder, rape, aggravated battery with a firearm, or possessing a weapon on the public way should be treated differently than a first-time offender and should be sentenced on the higher end of the range. And we preserve the ability for them to get time for their good behavior while incarcerated. The final thing I just want to say is that, there's been mention made that about the resources in community and dealing with the trauma that that begets violence. I just want to remind people that we did a good job on a bipartisan basis. Representative Gordon Booth was a sponsor, and Representative Sims was active on it, of sponsoring a bill that will bring those resources to community to deal with the trauma. We can walk and chew gum. We don't have to do everything in one bill, but we have to do something about this violence, and I think this will help.
Thank you, Senator. I see Mr. Jones actively trying to get to the table. So if you'd like to weigh in with some supportive testimony.
Thank you, Mr. Chairman. Matt Jones on behalf of the state's attorneys. I'm not going to speak For those of you who are used to this committee, I'm not going to filibuster and speak as long as I typically do. I'll be happy to answer any questions. I know, Christian, you're appreciative of that. But let me talk not about the penalty enhancements, the presumptive penalty enhancements and all of that, because I think there's been a lot of discussion about that. I want to talk about the balanced part of this, because it's something that the state's attorneys have been actively engaged in since, frankly, the task force by the governor was imposed, and not perhaps surprisingly to some of you, we've embraced the idea that reform is a necessity, and we want it to be smart reform. There are parts of the governor's task force report that we embrace and parts that we reject, and many of the things that are in this bill are the parts that we embrace. So, for example, the idea that you have a safe zone around a school or a church or a housing project or a park that is not tied to the children actually being there doesn't make sense. That was what the law was originally. Having it 1,000 feet was an arbitrary number. So we agreed that it ought to go from 1,000 to 500, and there ought to be a nexus so that the children actually had to be there. That's smart policy. If the goal is to protect kids, and kids aren't there, then this law doesn't accomplish what it's intended to do. Truth in sentencing has been widely criticized in some areas for being overly broad, and so while we reject the idea of alterations to truth in sentencing for murderers and for rapists, the lower category, the 75% where the bulk of offenses reside, we agree that there ought to be additional good conduct credits available for that population. It's one of the big drivers, according to SPAC analysis, in terms of why prison populations are going up, was because those truth in sentencing numbers, which take away discretion from a judge in some respects, are helping to drive those numbers. So we agreed to broad changes to that to allow for additional good conduct credits. We also agreed to expansion of, one of the issues that was driving was this issue of burglary to vehicles, which is a big number, particularly for youthful offenders for whom this is sometimes a lark, a criminal lark, but a lark nonetheless. So again, we found a middle ground there that if you're not doing damage to the property, it's a joyride situation, that's one thing. If you're getting in and you're breaking out the window and you're stealing it off a car lot, that's a different, and we've drawn the line in a way that we think differentiates that and lowers penalties for the more impetuous while maintaining the current penalties for the more property damage oriented. And then the other thing that was in this bill that I want to focus in on is language that we brought to the table in terms of expanding eligibility for diversion programs, whether it's the Offender Initiative or the Second Chance. Originally, you could get just one. Now you can get more than just one chance. The new diversion program for weapons is consistent with that. We're happy to answer any questions, but we think that these are important changes that show smart on crime and a balanced approach to offset some of the concerns about whatever penalty enhancements may occur for the other parts of the bill.
A lot of us, the question is often asked on the floor of the House of Representatives that if this bill is passed by the House and the Senate, whether or not the governor will sign this legislation. And I'm pleased to say the governor has indicated that he will sign this legislation into law if it does come to his desk. And I want to thank the governor and his staff for working with myself and also Senator Raoul and the city of Chicago of bringing this final product before this committee. So I thank you for your indulgence.
Thank you, Representative. Questions from members of the committee?
Thank you, Mr. Chairman. Thank you, Leader Durkin. Thank you, Mr. Superintendent, for being down here. A couple of questions. I think I'll actually start, since we've talked about it a bit, with the diversion program. And this question may be for Leader Durkin or maybe for Mr. Jones, whose testimony was disappointingly short today. So first is, my understanding, and it was noted at the beginning, that you would have to plead guilty to be eligible for this program. I'm wondering what we think the effect might be, given that in some cases, you know, for a Class 4, you can sort of plead down to a misdemeanor. Could we potentially, given the length and difficulty of the program, be putting more people in prison for longer rather than the opposite effect?
Well, with regards to that, I think it's unlikely that most of these people for the diversion eligible population would go to prison at all, unless they have it's just unthinkable that for these Class 4 offenses they're going to go to prison. We don't send them unless they have a very lengthy criminal history, and for first-time offenders without that criminal history, I don't think there's any statistics that say first-time, even UUW offenders routinely go to prison unless they fail and fail and fail and fail on probation. So
Okay, so walk me,
Possibly, theoretically, yes.
But walk me through this practically, Matt, and
Yeah.
here's why I'm asking this question. So the program is 18 to 24 months.
Right.
Has a pretty strict list of requirements, including things like dress code, attending programs, et cetera. So my understanding of the program is you go into it after having pled guilty to a Class 4 in this case, which does, I believe, carry prison time at least as a possibility.
Correct.
Right? So you plead guilty. You go through this program, let's say month 13, you forget to wear a tie that day, someone's feeling a little nicky-nacky, you drop out of it, you're back in the stream of prosecution. You're telling me that person is still probably not going to jail?
I'm telling you that in my experience, that person would not go to prison.
Okay,
Would they go to jail as an intermediate sanction, as part of a violation? Yes. I will tell you, in my experience, not wearing a tie for a day, I have never violated somebody for one single technical violation ever, even if it's dirty drug drops on probation. Oh, the dress code is, apparently the dress code language is taken out. So,
Thank you for that, Leader Durkin. So what's the success rate of the diversion programs you run currently? I believe the one in Brooklyn's about 50%, maybe a little less. What is it for you guys? And I know it's kind of a difficult question for an association, but what's the success rate generally?
it depends on the offense, to be quite frank. If you're talking about retail theft, then those are very high, are very high success rate. I don't have statistics for you. I'm not sure if Redeploy Illinois, which many of these specialty courts are funded through, would do it. I would say 50% is probably on the low side for most of the programs that we run.
Low side in terms of
Meaning
success.
we're more successful than those.
Okay. Couple more questions on some of the balancing amendment. So on the task force, the gun trafficking task force, my understanding is that the original version of the language had sort of tougher interdiction language allowing ISP to do direct enforcement actions. That I don't appear to see that language in this current draft. Why did that come out?
I think the intention was, as I talked with the Illinois State Police, and they're the ones who provided me with this amended language, was to gather information and to share it with, and to enter into multi-jurisdictional intergovernmental agreements with state, county, federal law enforcement agencies to provide whatever information they gather from this task force. But again, I think that was the intention, that was the goal of, at first with the Illinois State Police. The Illinois State Police are going to be very...
Sergeant Thompson can come forward and answer some of the clarifying questions.
Look, I can tell you this. The state police are actively involved with
I apologize, Lieutenant
working
Thompson.
with Chicago Police Department, the FBI, and also ATF on gun violence issues in the city of Chicago. And I talk to the superintendent on a regular basis of where the ISP is in coordinating with law enforcement in Chicago, particularly in these hot districts that we have in different parts of the city. So, but John, I'll defer to John Thompson on the amendment with the task force.
Thank you. John Thompson, Illinois State Police. I apologize I didn't hear the question precisely. I was standing by the door and a lot of background
So I
noise.
can repeat it if that's useful for you.
Sure.
So my understanding, and I know that this is one of the things that the Black Caucus was asking for and potentially trying to do something to make this more palatable for folks, was the idea of a gun trafficking task force at ISP that would be charged not just with gathering information, but doing interdiction, doing enforcement actions, being a force multiplier, not just for CPD, but for other departments sort of near the borders of our state where we know a lot of crime guns are flowing from. That was the original purpose, and it doesn't seem like this language is totally reflective of that, so help me understand why.
The goal of the task force is to basically complement those efforts. We have a lot of those efforts going on currently. You've probably heard the Ryan's Hope, the surge details that we've been doing in the Chicagoland area. The idea of this task force would be to pool all of our resources, make it multi-jurisdictional, and basically have intelligence-driven policing, and use this task force, use the information that's gathered, the sharing of information, the sharing of intelligence between us and even possibly federal partners, and direct our patrols and what we're currently doing to the right spots.
Well,
This all is about intelligence-driven.
just as a comment, because again, I know it was a request of the caucus, I know that one of the reasons why this was appealing really was as a force multiplier for other local police departments, and the idea was also to train and hire new officers to prioritize specifically doing this work. So I would just say that in terms of that being the intention, this amendment doesn't fulfill that purpose. I appreciate the work that's being done, but respectfully, the goal was to give you additional tools above and beyond what's happening already, rather than just to do coordination. I think the rest of my questions are probably for Superintendent Johnson, and they deal with sort of the effect that this may have on crime reduction. So first of all, Superintendent, thank you, one, for being here. Thank you, two, for your service. Thank you, two, for your commitment. We got to speak for a few minutes before this, and I am grateful that you are our superintendent for all of your service. A quick question in terms of what is the number of individuals we are expecting would be arrested, charged, sort of put back into the stream of prosecution, and hopefully, I guess, sent away under this bill?
Well, you know what, I don't think we have an exact number, but you know, like I said before, we are not targeting, we're not focused on using a net to cast a wide net to lock up everybody. The purpose is to create a culture of accountability so that people won't want to pick up a handgun and use it in a violent way. The idea is not to incarcerate more people. If this bill is passes through, then I think that in time it would help create that culture of accountability. You know, violence in Chicago is not one simple solution. There's pieces that have to be in place. You know, the economic opportunities, the job opportunities, more mental health care, housing, better housing, all of those things matter. But we still have to hold repeat gun offenders accountable for their actions.
So I appreciate that, Superintendent. Respectfully, it wasn't quite an answer to my question. So I know that there's been a lot of coverage, for example, of the strategic suspect list in the city of Chicago, and what I'm wondering, my understanding was that this is a relatively small number of people who would be directly affected. I'm asking you, for the sake of this committee, to sort of to give us a ballpark. How many people are we talking about here?
So when we look at the strategic subject algorithm, there's about 1,400 individuals that are driving most of the violence in Chicago. And I'll give you an example. Last year in Chicago, 85% of the victims that were shot either fatally or non-fatally had been identified with this algorithm. So we're targeting the right group of individuals. So you're talking about 1,400 people.
And most of those folks would fall under the net of people who would be second-time violent gun offenders?
Correct.
Okay. Similarly, because I know you guys do a lot of work on data, CompStat type stuff, et cetera, assuming that this bill passed, is there an estimate to how many shootings, whether fatal or not, we might be preventing by passing this bill?
I think over time we would cut it down to half. I do believe.
So if we pass this bill over time, are we talking 3 years, 5 years, 10 years? What kind of time?
I don't think it would take that long. So I would say we would probably start seeing a reduction in less than a year.
Okay, so in less than a year, but certainly it's safe to say in 3 years, if we pass this bill, we should see about a half reduction in the shootings and crime in Chicago.
The gun violence, correct.
Okay. A couple more questions, because you mentioned guns and you also mentioned economics. We did gun dealer licensing in this committee on the 16th of May. You came down for this bill, sir. Why didn't you come down potentially for that one? I know you're very busy, but wanted to ask the question.
The gun violence bill?
We did a bill to license gun dealers. So as you know, there are a couple of gun shops in and around Chicago that supply a very large majority of the guns that you and your officers find next to the bodies of these kids in Chicago. We had a bill to regulate those folks that was up in this committee on the 16th of May, and I'm just wondering, you know, bluntly, why you weren't here, sir.
Okay, well, I wasn't made aware of it. That's the first reason. But let me say this, sir, that, you know, given the fact that we don't have gun shops in the city of Chicago, I do recognize that the surrounding areas are contributing to that gun violence. And to the extent possible, had I been made aware of it, I would certainly come in support of regulating that.
So I appreciate that, sir. And again, thank you for your service. And I intend to vote for this bill because I think that the kind of people that we are talking about ought to be in prison. But I do think it's going to be important for this committee, based on the numbers that you've just given us, to measure the effectiveness of how this goes. And assuming that it is not as effective as is being projected, that we return with the will to do the work on guns, on jobs, on other things that are really going to drive the numbers. So again, Superintendent, thank you for your work, and I'm appreciative of your service.
One thing I just want to add, I was just provided with information about whether we think that the diversion program will bring success, and is there anything to measure that from. In Cook County, the last numbers showed a 70% success rate with their diversion program. So I do believe that there is value in this on that first-time offender.
Thank you. Representative Stratton.
Thank you, Mr. Chair, and thank you to the bill sponsor and to Superintendent Johnson. Thank you for being here as well. I want to come back, and Superintendent, I appreciate the anecdote about Mr. Rogers, but I would really like for you to share more of the data that supports that this is the type of approach that will work towards reducing gun violence.
Well, right now, ma'am, I don't have that particular data in front of me, but I would be more than happy to share it with you at a later time.
Okay. Thank you. I know that you talked about trying to pinpoint individuals that are driving violence in the city of Chicago, and it's already been brought up about the strategic subject list that you've talked about. Now, this subject list includes both those that are likely to be victims of violence as well as perpetrators. Is that correct?
Correct.
All right. So, and is there a sense, because my understanding is as we look at trauma, that victims and perpetrators are often the same
Correct.
people, correct?
Correct.
All right. So can you tell me then, when you think about this particular piece of legislation, and I know you don't have the data before you, at least the numbers in front of you, but can you tell me what you do know from research, just even generally, about why an enhanced penalty would be helpful under these circumstances?
Well, this is what I can tell you, ma'am. I've been a cop for 29 years, and I've done nothing in Chicago but chase bad guys around. And most of those bad guys had guns. And what I can tell you is this: when you create a mental culture of accountability for these gun crimes, they react to it. If they know that there's no consequence for their actions, we're not giving them an incentive to stop doing what they're doing and putting these guns down. So the idea is not to arrest more people. The idea is to create that culture of accountability, because I do know that people that perpetrate these gun crimes, they talk to each other. They see what's going on. And once we send a strong message that if you commit these crimes repeatedly in the city of Chicago, we're going to hold you accountable, when that message gets out there, they will start putting these guns down.
All right, and so do you have data to support what you've just indicated, that a culture of accountability? You brought sound effects. Is there any data that you can provide or share with us today that supports that through a measure such as enhanced penalties, that it will in fact create that culture of accountability? And if I may, the reason why I ask this question is because we know that since 2000, over the last 17 years or so, we have seen enhanced penalties in Illinois. We have seen mandatory minimums. We have seen the penalties get enhanced. And we also, at the same time, we have seen the type of year that we had in Chicago last year, where violence continued to increase, at least in the last year, maybe 2 years. So anecdotally, it would suggest that those penalties have not, in fact, created that culture that you're talking about, and that perhaps there are some other measures or factors that actually create a system of accountability within our culture.
Okay, that's a great question, and I apologize again for not having that data in front of me. So what I can tell you is this: yes, we have had mandatory sentencing laws in Illinois before, specifically Cook County. But what I can tell you is this: having the laws on paper and actually using them is two different things. We've had those laws and those mechanisms in place. We just haven't used them. And that's why they don't see the accountability that we need. And this is another thing anecdotally I can tell you. In the 1990s, when I became a cop in 1988, our murder rate was routinely 800 to 900 people a year. In the early 90s, we changed the state law from making unlawful use of a weapon. We changed it from misdemeanor to felony on paper. When the word got out in the community that that law had become a felony, that if you got caught with an illegal handgun in Chicago, you were not going to get charged with a felony. When that happened, for about the first 8 months after that happened, we couldn't find a gun in Chicago. That's because we had created that mental culture that they didn't want to pick up a gun. But what happened as they started getting caught with guns and going through the court system and saw that it was still treated like a misdemeanor, we took that accountability away. The incentive to not pick up the gun was no longer there. So what I can tell you is that it does make a difference. If we create that culture of accountability, they will start putting those guns down.